Hello and welcome back to Lunchtime BABLing. My name is Shea Brown. I'm the CEO of BABL AI, a company that audits algorithms for bias, ethical risk, and effective governance. I am joined once again by our Chief Operating Officer, Jeffery Recker. Jeffrey, welcome back. Great to see you again.
Likewise, thanks for having me on again. This is becoming quite a regular thing. Nice to flex the brain and talking about these various topics.
Yeah. So what are we going to talk about? I think Colorado seems to be the hot thing. So what's up with this?
I very specifically wanted to talk to you about the new law that was passed in Colorado. So for those of you that don't know, um, so I, we have some articles and some content on this on our website. So I'm going to kind of read things off, and we can go through it. But the bill is titled "Concerning Consumer Protections and Interactions with Artificial Intelligence Systems." So basically, this is like almost like a mini EU AI Act coming out of Colorado, um, and it's specifically for both employers and developers of AI systems, hoping to safeguard consumers from algorithmic discrimination. So I just want to talk about this, kind of talk about it high level, like what this means for deployers, developers, the average consumer, et cetera, et cetera. So I guess we can just kind of start right there and just say, what do you think of this? What do you think of a state kind of taking this initiative rather than at the federal level? Any high level implications do you see coming from this?
Yeah. Well, I'm glad states are acting. I think this is in general, this has been the trend that we saw it with New York City. DC's tried to pass things a lot of state uh, at the state level, a lot of initiatives to regulate AI. And Colorado is an early adopter here, so it's not the first time Colorado's sort of broke new ground. In that, the last year they're in insurance AI and insurance law, so they have their own law that's regulating how uh, underwriters, for instance, if you're using AI to underwrite insurance, or if you're an insurance provider that's using AI, um, you have quite a number of requirements that are not dissimilar from what's happening here. So the I think it's good. So I think it's a good step in Colorado. It's not surprising that they're doing this because they have been on the cutting edge, and it does feel like a mini EU AI Act. It is very similar. So for those who are familiar with the act, some of the terminology is a little bit different. So developer is what the act would call a provider, and the deployer is the same. One key difference I'll highlight here is that in this law, the focus is primarily on discrimination. That's one of the things that called out in particular, as opposed to the EU AI Act, where it's one of many things that are considered. And in fact, the mention of bias in the EU AI Act is not very, or discrimination is not very prevalent. It's only in a few places. Whereas here, there is definitely a focus, and I think that's because of the American. Uh, that's part of the American history, is this idea of discrimination, and the worries about algorithmic discrimination is definitely kind of started in the U.S. With a lot of researchers here, and so it's not surprising that that's the focus as well.
So before we dive into this bill a little more, I kind of want to poke a little bit in your thoughts of Colorado kind of taking this initiative. Because as you highlighted, they also have that insurance law. This was signed by the governor just recently here in May. Um, what are your thoughts on Colorado taking this initiative with all of their AI laws? What are your thoughts on states kind of taking initiatives rather than it coming from the federal level?
Well, I think I'd prefer it coming from the federal level. I think that's there's no doubt. I mean, just from like a business perspective, because we do work with businesses trying to navigate this, and it's hard when you have 50 different regulations that you have to worry about. And so it's much easier to have a federal level requirement. The problem is at the federal level, there's a lot more attention, a lot more lobbying, and you're going to get more watered down laws, which is good and bad. Um, But what it does is it potentially supersedes some of the state level regulations. And so I kind of, if I had my choice, I'd prefer sort of stronger, more sensible state regulations than a broad, sort of not very well articulated federal policy. I think that's my take on it. Is that I'll take this if that's all we can get, but it would be better to have a federal level approach.
Yeah, yeah, agreed. You know, we were, Babel had some people in DC a few weeks ago talking to various people and just being at events, looking at federal policies that may or may not be in the works. And it just feels like not much is going to come, especially in light of an election coming up. And for my concern, would be that just makes the web of complexity so much more complicated. If the federal government takes an initiative on this, then there's kind of, you know, it's like a north star for companies to be guided by. But instead, if you have all of these various laws popping up, you know, not just Colorado, you get California, you got what's going on in Connecticut, New Hampshire, um, Utah's got something in the books now. You got all of these deep fake laws, election laws, just various different things for different things, HR laws. Um, and it just makes things so complex. And there's nuances where if you have a hiring law, say the New York local law 144 that we talk about a lot, you know, how does that align with California's law coming? Or how does that align with the state of New York that has got some things proposed, or all of these other various regions? It makes it so much more difficult for companies to navigate.
Yeah, I mean, 100%. Like you, I mean, a big part of what we do when we're in terms of our research is really mapping how those all overlap. Like, what are the common features? And the good thing is, there are a lot of common features that are really common sense, risk management, proper documentation, proper testing. Uh, that those kind of things aren't going away, and they are very common. And if you do those, then you're going to get a huge amount of coverage. And then it's just the edge cases. Then you got to worry, which are important, of course. But that's the whole game. That's why people get help to do this, and or they build an internal team that can do it. It's pretty high stakes, potentially, and it's just going to get worse. The regulations are going to keep coming.
Yeah, for sure. So let's dive into this a little bit more, and I think I'm just going to go through some of the things that are in this and kind of get your thoughts on it. So, to start, for deployers of high risk AI systems, the bill mandates that they exercise reasonable care to avoid algorithmic discrimination arising from the intended use of their systems. So, when you hear that, what do you think? What do you think a company should do when they're developing these systems to comply with such a thing?
So the spirit of the law is that you are paying attention to the potential for your system to discriminate. I mean, there are going to be other risks that you have to worry about, but they're calling out discrimination in particular, and that includes things like bias testing. That includes things like having proper risk assessments, uh, and importantly, documenting those things, because what you want to be able to do is to demonstrate to the attorney general in Colorado that you have done these things. And so, I mean, our approach is always start with proper risk assessment, and first, that risk assessment is going to identify different metrics you need to measure. Bias is clearly going to be one of them, but how do you measure bias? That's not super easy all the time. It's almost never easy. And so, getting a handle on that, getting some tests, getting some insight into how these systems work, and then documenting that. That's the sort of the duty that they have, and they have to be able to demonstrate that.
So, what do you mean when you say a proper risk assessment?
Yeah, good question. So proper risk assessment is not, I have a certain list of questions I'm going to ask my developer, and when they answer me, I'll write it down and I'll make a checkbox there. A proper risk assessment is really identifying who are the stakeholders that are involved, what are the with a focus on the consumer, right? Because this is what that law is focusing on. Thinking about what are the potential risks to them. Now, in this case, they're calling out specific risks, discrimination, right? So whatever service you're providing, whatever the AI is making some consequential or assisting in a consequential decision, that's going to somehow have an impact. So think about what is that negative impact, and then you try to articulate like what are the ways in which that could happen. What are the various features of the system that could give rise to that negative impact? And then the mitigation process, that's the risk assessment process, trying to calculate what's the probability, what's the likelihood that's going to happen, what's the impact when it does. And then the mitigation step is, of course, is knowing that these features are going to potentially cause that. Let's drive down the probability that happens with some kind of control, or let's mitigate the impact if it does happen through some mechanism, giving people choice or something like that. That's the basic idea. That's the way you should do it. Um, Unfortunately, there's a lot of checkbox exercises which aren't that effective. But if you do it the way I just described, you can see the levers that you need to turn to mitigate those risks. And then that's a very good narrative to have if the regulators come calling. It's much better than say, look at my checklist. It's like, hey, we have a very structured procedure. And the end result is that we are lowering the probability that we're going to discriminate against people.
Yeah, that was great. And I'll also say if people want to learn more about that, we talk about risk and impact assessments quite a bit. We have lots of content both on the website and Lunchtime BABLing, so you can go back and reference if you want to learn more about that. You also hinted at the next thing I was going to bring up, and that is developers must provide documentation to deployers detailing the AI system's capabilities, limitations, purpose, intended use, training data, evaluations for discrimination, risk, and more.
Oh my. So that's hard. And this is one of the harder things because we're working with people on the EU AI Act and it requires the exact same thing. There's an article on it. And that that it takes a lot of work because you have to really, when you're developing these systems and when you're working internally, you don't always document everything in a way that is going to be clearly understandable by external parties. So this goes all the way from like documenting physically, how does that algorithm work or the AI work? What kind of training data did it use? How did you test it and all of that? But all of the risk management stuff on top of that. And then also instructions for how is the end user supposed to use it in a way that's going to minimize risk. All of that is stuff not typically done by most companies. And so it's a lot of work and you have to have cross-functional work. So the developers and the product owners have to talk to legal and compliance because you have to craft that communication to the deployer in a way that is going to minimize risk for the deployer, minimize risk for you, and ultimately, according to the law, minimize risk to the consumer. And so that's hard. It's not impossible, but it's obviously it's not impossible. But it does take a significant amount of work and resources to do it.
Yeah, for sure. And you hit it on the nail. Like we talk to people all the time. It is a lot of stuff. Get started on this now. Don't wait. You know, you want to start early and start working towards it before regulators come in and you really need your stuff in order. I'm going to lump the next two into one. So developers must also publicly disclose the types of high risk AI systems they have developed and how they manage risk of algorithmic discrimination. Additionally, developers must disclose any known risk of algorithmic discrimination to the Colorado Attorney General and deployers within 90 days of discovery. So, what is an effective way that a developer can do this?
So if you do the risk assessments, like how we recommend you do them, then the documentation of how you're mitigating that risk becomes very clear because it's about the process in which I just articulated. And so you're going to articulate that process for public consumption or for the consumption of the attorney general. So that's priority number one. So always like mentally, you need to be thinking, what's the end game? What are we actually trying to do? That's minimize risk to the consumer. So if you have that in your mind, structure everything in terms of functionally and also narratively in terms of the documentation towards that end. Um, the trickier bit is going to be, so this has to be, there's a public facing version of this. And so some of the trickier stuff is how do you articulate that in a way that doesn't give away your secret sauce or some sort of something that you is going to increase your risk. That's takes some careful thinking, but it's not impossible. I think you can describe how an algorithm functions very easily at a high level that is going to give you enough detail to understand it without giving away too much. The harder part is going to be this deal about notifying potential risk of discrimination 90 days. That's tough. So in order to do that, you have to internally have a procedure and a threshold and a metric or a KPI, let's say, that is going to be tracked that will raise an alarm for when it's kind of significant risk that has to be disclosed. And so that's not easy. And I don't have any easy answers for people. It's going to be really use case specific, but it's going to be something that's important to articulate clearly and justify what that threshold is, because you don't want to be sending a ton of notifications for no reason. If you just suspect that maybe there's something going on, you really want to understand what's going on so that when you do send something, it's for a good reason and you have a clear plan on how you're going to deal with that. Because if you send a notice, somebody's going to come looking at what that is, and so you have to really have uh, everything buttoned up pretty well and know like what happens. Think through the exercise. What happens if we get this flag? Whatever metric we come up with, what are we going to do? What's our plan? We're going to have to communicate it, but then how are we going to mitigate that? How are we going to demonstrate that duty of care, that good faith effort that we're trying to make sure that discrimination doesn't happen?
Yeah, that was a great overview. Um, so I'm gonna jump into the developer side of this, and then we can kind of come back and look holistically at the whole thing again. And apologies for any overlap between the developers and the deployers. I will say that the context changes, so I think it's important to highlight. So for the first one, deployers of high risk AI systems, the key requirements are that they use reasonable care to avoid algorithmic discrimination and implement a risk management program to identify and mitigate discrimination risk.
So this is where like it's essentially going to be the same thing, except you're right, the context matters. The risk management system should proceed in the same way I just mentioned. The only difference is the deployer is the one who has the full context of what's going on. So for the developer, they have a limited context about how their system is getting used. They have some visibility, of course. They have some. The reason that language of intended use is in that first part is because the developer only has that. Like they don't know actually how that's going to be used, but they know how they intend it to be used. But now here in the deployer section, they know how they're using it. And so that risk assessment has to take into account, let's say it's a hiring algorithm, like how are they actually interpreting the numbers that get put out of that algorithm? How are they using it to filter candidates, let's say? Or if it's an educational setting, which is in the high risk, but we haven't gone over that, but they're education, high HR, like those are in the high risk categories, very similar to the EU. And so it, if it's an education context, they know how they're using it to, let's say, select students or accept students or to proctor exams or whatever it is. And so that risk assessment is you're going to have more access to some of the front end risks in terms of the human interface and how and the judgment calls that get made. Whereas the developer is going to have much more insight into things like the bias metrics. But that's what the communication part is for. The developer is going to give the deployer all of that information, and the deployer says, "Oh, okay, they did some tests, and there is some false positive rates at the end this amount, and so how do we make sure we mitigate that kind of thing?" That's what that's about.
Yeah, that was again great overview. And yeah, the context of this changes that's going to be relevant for this next one, which is deployers must conduct impact assessments of their deployed high risk AI systems at least annually. Before you jump into that, I'm going to add an asterisk here, and basically, AI is kind of hidden in a lot of places. So I feel like this is going to be a little more difficult than one might realize.
Yeah, there's AI creeping into a lot of services. Like if you're using a platform to source candidates for a job, let's say. So just to stick with the HR context, um, are they using AI to filter what you see? Do you know whether they do or not? Because there are like some open platforms like Indeed or LinkedIn or things like this. And then there's more closed, like, B2B software as a service type, the kind that we typically audit, where, it's not open to everybody. It's like you have a account manager who's walking you through these things. And so you have more visibility, but it's the bigger ones that you may not even know that AI is there. And so you're right. It's going to take some inventory and some careful thinking about where does AI exist. And the impact assessment, it probably sounds a lot like the risk assessment, and in many ways it is. But the point of the impact assessment is that you are trying to assess over, let's say, a particular time period, like how did things go? Like the risk assessment is like, where are the risks? How do we track it? What policies do we use to mitigate it? Impact assessment says, okay, over the past year, here are all the metrics, here are all the incidences that we might have found. Here's how we what mechanisms we used and how that and what the ultimate result was. What was the impact that this algorithm had, and focused on discrimination, the potential for discrimination. And that's something that gets done every year, and it's more of a retrospective as opposed to kind of proactive.
So here's the next one that kind of touches on this a little bit on the transparency side for sure. When using high risk AI systems to make consequential decisions about consumers, deployers must notify those consumers.
Yep, this is going to become standard. New York had this, EU AI Act has this, like if you use an AI to make some critical decision, you got to tell people. I think that's going to be table stakes in terms of regulation. And so thinking carefully about how you notify them, that's not easy. But yeah, it's going to be, everybody should be preparing for this.
Yeah, and again, I think people are going to have to really think about this because it is kind of just sneaking into a lot of places. Like, do you have some type of transcription being used to take meeting notes or something? Or, someone's on the other side of a screen and you're just, how's that transcription? Is there some AI that's making a decision after the fact? It definitely needs some consideration to really evaluate all of the AI tools that you kind of have, and think to yourself, which ones do we need to really start doing this for? Um, Moving on to the next one. For any adverse decisions, impacted customers must be provided the reason for the AI decision and an opportunity to correct data or appeal the decision.
Yeah. So this is sort of borrowed from like some of the fair credit kind of um, laws and standards. And so it's basically, you deny me for a loan. I want to know kind of roughly what criteria you use to make that decision. And if that's based on information about my, let's say, credit history, I want to know about that, be able to correct it. Right. That's the basic idea. That's why we've got access to some of these scores now, and we can update information and or make corrections. Just translate that now to other critical decisions. So you didn't hire me, right? I'd like to know why. What criteria did you use? You already told me that you're using AI. So what criteria did it use? And where did it get that criteria? Was it from my LinkedIn profile? Well, you didn't correctly read my LinkedIn profile because I put this and you have it as that. And so I want to correct that. So that's the basic idea, is that for any of these critical decisions now, away from some of the financial credit stuff, which kind of already exists, giving people the opportunity to understand how their data is getting used to make that decision, understand the algorithm itself to some level, at the feature level, and then being able to look at the data that about you that it got to make that decision and make corrections if you think it's wrong.
So the last one here: deployers must also publicly disclose the type of high-risk AI systems they deploy and how the discrimination risks are managed, as well as notify the Attorney General of any discovered algorithmic discrimination within 90 days. This is similar to the developers, but again, I think it's just a different hurdle for deployers, right?
It's different, and I think the stakes are higher for deployers because a developer will have limited visibility, and so what they're tracking in the background is like potential metrics that might be like, oh, the system seems to be there's some drift in the system that I think is gonna could affect people, and it's not at the front end, and at the front end is where the deployer is actually making those decisions, either algorithmically relying on that algorithm to make the decisions or using it to inform the decision. And so they have more responsibility for this and more liability. And so it's the same kind of requirements, but I think the stakes are higher. And the same considerations have to be, you do need a plan and a threshold, and exactly when are you going to report, what rises to that level, how are you going to justify that and articulate that, and what's the plan when something does happen to demonstrate sort of good faith efforts to comply with the law.
Yeah, so for some context, the bill also outlines exemptions for compliance, say with other laws, research activities, national security applications, regulated financial institutions, following equivalent AI governance frameworks, and more. Um, so, talk to your legal counsel, try and understand how this bill affects your organization if you're operating in Colorado. Also, it takes effect February 1st, 2026, which feels like a long time. But again, we're working on this stuff for EU and for other things as well. It's it's not something.
This is before EU. This comes into effect before the EU, before the high risk requirements for the EU. This comes into effect before that, so quite a few months.
Yeah, and the point I'm making is just it's not something that you can get done in 90 days. I think it's going to take a considerable amount of time to get all your ducks in a row.
Yeah, absolutely.
So let's round this out. So tell me, just high level, what are your thoughts on this? The good, the bad. Just what do you think?
Well, I think the good is that something's getting done. That I think forcing companies, both deployers and developers, to think about these issues and do something about it is good. It's important, and I think we need to do it. The downside, well, I'll go to the downside, then I'll go back to another good side. The downside is that it's work. It's a lot of work, and it's not going to be trivial. Um, and there, and so to your point, like starting sooner rather than later to think through these issues is going to be important, because it's not going to it's not, you can't just roll this out in no time. You have to think very carefully, because you're getting exposed to a lot more risk because of the transparency requirements and the fact that the enforcement, they're going to look at your books, so to speak, in order to verify this stuff. Now, the other good news is this significantly overlaps the EU AI Act. And so if you're a multinational or you're a big enough company that you have European clients, or you're operating in Europe, and you're a provider or a developer in this case, then you can do double duty by just making sure that you look at the overlap, and there is significant overlap. It's almost exact, except for the focus on discrimination and some of the local, like the way that Americans conceive of discrimination legally. But just do it holistically. Do it as, just say, we're going to comply with both of these. There's a ton of overlap, and just check the edge cases. But you should be able to set up a quality management system, which is not really discussed in this law, but the EU requires it. And probably the core of that quality management system is that risk management system, and the technical measures and documentation that flows out of that. And the good news is there is significant overlap. You can get them both done. You just got to start now.
Yeah, for sure. And I'll just end on this note. If you want to learn more about this, again, you can just follow our website. I just want to thank Jeremy. He writes a lot of our content, especially our news and our blog. He's been covering this over the last few weeks. Give him a follow on LinkedIn if you want to learn more. You can also follow our newsletter and subscribe to that, which is at our website. Subscribe to YouTube as well. If you have more questions around this, don't be afraid to reach out to us or ask questions in the comments, and uh, we can always follow up.
Yep. Yeah, exactly. We'll put some links to the like the newsletter and stuff in the description below. And as always, if you could give us a like and a subscribe, that really helps us out. We appreciate you spending time with us, and we'll see you again on the next Lunchtime Babbling.